Welcome, I'm Jon Caldara, president of the Independence Institute and your devil's advocate. A little later in the program, a look at Udall and Obamacare. But first, there is a huge lawsuit that's making its way through federal courts, and it has all to do with you, that is, if you pay taxes in Colorado. To explain this from the Independence Institute, our legal scholar, Rob Natelson. Thanks for being here.
Good to be back again, John.
All right. This is one of those, like so many other things that are wildly important, hard to follow. It's kind of like the budget, and when the legislature fights over the budget is the singular most important thing they do, but it gets no press coverage because it's kind of hard to understand, and it's not guns or abortion or something that you get really passionate about. This is a lawsuit over the Taxpayer Bill of Rights. Give me the background.
Sure. The Taxpayer Bill of Rights is a part of the Colorado Constitution. It was adopted in 1992. And it consists of a number of fiscal restraints, that is to say, limits on the ability of the legislature and local governments to spend money. The limitations require the legislature, if they want a tax increase, to go to the voters. Sometimes they can pass an emergency tax by a 2/3 vote without the consent of the voters. Also, certain spending increases have to be approved by the voters, other than those that result from inflation and natural growth. And certain debt expansions have to be approved by the voters. And so it's called the Taxpayer Bill of Rights because it gives to Colorado taxpayers the ability to veto tax increases.
Most of us who are political junkies have strong feelings about Tabor one way or the other. Everyone says the best part about Tabor is that you get a vote on future taxes. Other people are not excited about the limit on spending, but we don't need to get into that. This was not part of the original Constitution here in Colorado. This was brought forward by the people. It was written by Doug Bruce, and it was voted on in 1992 after several failures that were very close. The third time around, it passed, and it passed by a vote of the people, and it was put on by the initiative process. That is, we got enough signatures, we got it on the ballot. At heart of this legal challenge that's now coming up against Tabor, it's not that Tabor's bad or Tabor's good. It's that Tabor's unconstitutional, not with the Colorado Constitution, but the federal Constitution. I am not understanding this argument. Help me understand.
Well, first, by way of introduction, Tabor, while we sometimes refer to it in Colorado as a unique restraint, isn't actually all that unique. States started adding limitations on the ability of their legislatures to borrow money back in the 1840s after several states almost went bankrupt. And Tabor was one of a series of measures adopted in the 80s and 90s among the states, or actually starting in the 70s, as a result of government overspending and the economic havoc that resulted, the budgetary havoc that came from government overspending. The argument of the plaintiffs, who by and large represent public sector interests, is that this provision of the Colorado Constitution violates the federal Constitution. And in particular, they argue that by restricting the legislature's fiscal powers, that puts the state of Colorado out of compliance with that part of the U.S. Constitution that requires every state to have a Republican form of government.
All right. Well, let me kick this back to you. Federal Constitution, big deal, big fan, love it, Bill of Rights, good stuff. And it says that we have a Republican, small r, this is not the Republican Party, but a Republican form of government, meaning which we elect people to represent us. It's not a direct democracy. It is that we elect these people, and the people of Colorado, those legislators, didn't give us Tabor. We rabble. We gave ourselves Tabor, and as a restriction on the government. This lawsuit says it can't be. The initiative is bad, or what the initiative does is unconstitutional. Which one? That the initiative process, me asking the people of Colorado to vote on something, or the fact that Tabor says, listen, if you want to raise taxes, you have to ask first, which never seemed like a big deal to me.
To be honest, John, the theory of the plaintiff's complaint isn't very clear. If you read different parts of what is a very long complaint, they seem to be saying different things at different times. At the Court of Appeals level, they argued that they are not challenging the initiative and referendum process as such. They're arguing only the kinds of restraints that are imposed by Tabor. But fundamentally, they rely upon an old story that goes back to the middle of the 19th century. The basis of the story is that in order for a government to be Republican, all the decisions have to be made only by elected representatives, not by the people. And that is not the way the founders saw it. That's not the meaning of Republican in the U.S. Constitution. The meaning of Republican in the U.S. Constitution basically means a popular government as opposed to a tyranny or a monarchy.
How do you know this? I mean, you're old, but you weren't that old that you knew that. How do you know that the Constitution, the United States Constitution, saying that we're going to have a Republican form, didn't include things like the initiative process that we use here in Colorado and many other states?
Well, because the founders left us a lot of information on what they meant by Republican form of government. James Wilson, the man who was probably second most influential to Madison in creation of the Constitution, said that a republic is a government where the laws are made either by the people or their representatives, either one. And at the time the founders had wrote the Constitution, historically almost all republics that had ever existed, the people themselves voted on laws. It was actually the American government that was a little odd, where we didn't have direct democracy at the federal level, but they certainly would have recognized it as permissible, if not necessarily always advisable, at the state level.
Well, not only is it allowed from the United States Constitution that we, simple peasants who actually pay taxes, have a say in this, but the Colorado Constitution gives us the right to the initiative and referendum process, doesn't it?
In fact, the Colorado Supreme Court has actually said that initiative and referendum are keystones of Republican government. So they consider that an important aspect of Republican government. Look, Republican government basically means, it comes from a Latin word meaning the people's affair, the people's matter. Republican government basically means popular government. If a state wishes to limit its legislature, it may do that under the guarantee clause and remain Republican. I'll tell you, John, theoretically a state could even abolish its legislature. Some republics in history have operated where everything is judged by the people in the public square. But we don't need to go that far. Tabor clearly meets the constitutional test. But what's important here is that this lawsuit hasn't dealt with that issue yet. It's dealt with other issues.
Well, on this issue, if they win saying that people can't change the government by the initiative process, that means the same thing would apply for our term limits, for open records, for Amendment 23, which is funding of schools, for all sorts of things that have given us a check and balance. All those would be thrown out, not just in Colorado, but all over the country.
That's right. It does. That's exactly right. It goes all over the country. We issued early last year at the Independence Institute an issue paper which talks about the attack on Tabor and the threat to other states. Every state constitution, with the exception, I believe, of Vermont, has provisions in it that limit the legislature in a way that the plaintiffs in this lawsuit seem to feel unacceptable. Balanced budget requirements, requirements that voters vote on debt, flat limits on how much debt a state can undertake, and in about 8 different states, provisions in their state constitution that look a lot like Tabor. So if this lawsuit is successful, you're looking at legal havoc, not just in Colorado, but across the country.
Let's assume that part of the suit, let's put it aside for a second, the initiative part. There's something else saying that, let me see if I got this one right. Taxing policy is the purview of elected officials only, and therefore somehow we, the people, shouldn't be able to give it a thumbs up or a thumbs down as we do with Tabor. Tabor merely says, ask first. That's all it is. Government can grow at whatever rate we want it to grow at. All you have to do is ask the taxpayers, and that's it. Yeah, what's the legal argument that they're trying to make that that's somehow against the federal Constitution?
Well, that's what's one of the things that is puzzling, because their use of authority is very sparse, but their complaint itself, as I said, seems to vary. Sometimes they seem to accept the idea that you might have some provision for popular input into fiscal questions, but at other times, such as when they call for the complete elimination of Tabor, including its very traditional debt restrictions, sometimes they seem to be saying that any restriction on the fiscal power of the legislature is not permissible. And that is one of the troubling things about this latest Supreme Court opinion, because they upheld a lawsuit where
Which Supreme Court?
I'm sorry, a Court of Appeals opinion, right, because they upheld a lawsuit that the state really doesn't know the parameters of.
Let's have a scorecard going on here. Lawsuit was entered in federal court. That's the interesting thing.
Yes.
It went through the first federal judge. That first federal judge said, yeah, you can proceed with it. That was then went to the Court of Appeals, and they said, yes, you can continue with this lawsuit. They didn't rule on the lawsuit, is that right?
They didn't rule on the merits. They ruled on the standing issue and justiciability issue. The standing issue is these plaintiffs, who are Colorado state legislators, may sue, okay? The second issue, the justiciability issue, is they said there are adequate guidelines, legal guidelines, for determining this case, and therefore the case may proceed. It's the latter part of that decision that I have some problems with.
Why wasn't this kicked out? It seemed to me such a laughable measure that the idea it's getting a day in court is ridiculous. So without getting too legalese, it would seem to me a court judge would go, wait a second, the legislature is the people is the legislature by state constitution and by the reasons you said, so this thing isn't going anywhere.
One decision that the Attorney General made early on in this case at the trial court level was not to contest the plaintiff's claims about TABOR violating the Republican form of government. The Attorney General dealt with the standing issue. They defended on that basis. They defended on the justiciability issue. It wasn't until the appeals court level that the Attorney General started pointing out, quite rightly, that there's no grounds on which you can claim TABOR is unconstitutional. This latest Court of Appeals decision says that's too late. The Attorney General should have raised this issue back at the trial court level.
All right, so if the AG did this earlier, it might not have gone to where it is.
Right. Now, it is going to go back to the trial court, assuming the Attorney General doesn't take further proceedings. It's going to go back to the trial court, and then the question of whether TABOR violates the Republican form could be a subject of another motion by the Attorney General to dismiss.
In other words, we still have a long way to go.
We still got a long way to go, and this case has been going on since 2011.
All right. We've only got a minute here. Tell me what happens next. So put on your wizard's hat and tell me, where does this go? Because it seems to be a wonderful distraction. I don't see how it's going to win, but what happens next? If you were the AG, what would you do?
Well, unfortunately, John, I left my wizard's hat at the Independence Institute, but let me try without it. The Attorney General has a choice. The Attorney General can say, well, let's go ahead and go back to the trial court and battle out the merits of the trial court. That's one possibility. Secondly, the Attorney General can apply for a writ of certiorari, that is, ask the U.S. Supreme Court for review. That's a very long shot. Thirdly, the Attorney General could ask for what's called en banc review. That means have all the judges of the United States Court of Appeals for the 10th Circuit review the case of this three-judge panel. I'm not a legal strategist, actually, but that's probably the course I would recommend.
All right, real fast. If this was to go to court, all the arguments are heard, are you pretty confident that taxpayers win in this one?
If it goes to the merits, taxpayers ultimately win on the merits. Of course, they lose because they have to pay for this litigation, which has already gone on for quite a few years and may go on for quite a few more.
Rob, thank you. By the way, the book, The Original Constitution, at Amazon. Even I can understand the Constitution after reading this. Thank you.
Thanks,
Stay
John.
tuned.